Welcome. Today we're going to talk about a topic that lies at the very heart of medical practice, one that goes beyond science and skills, the medical act. You see, every time a physician interacts with a patient, something more than a consultation happens. That interaction carries legal weight, ethical depth, and clinical purpose. This session aims to define the medical act as a technical, scientific, and legal action that creates rights and responsibilities for both the healthcare professional and the patient. We'll explore what gives this act legal form, why it's central to your role as future physicians, and how it's regulated. It's not just about what we do, it's about how we do it, and under what standards, obligations, and protections. Let's begin. Let's take a deeper look at what makes up the medical act. It's not just a technical action, it's a complex, multidimensional process that integrates four key aspects: technical, scientific, ethical, and legal. The technical dimension involves your skills, how you examine a patient, interpret findings, perform a procedure. It's about precision, training, and clinical judgment. Then we have the scientific dimension, the foundation of evidence-based medicine. It means your decisions must rely on up-to-date knowledge, validated protocols, and scientific reasoning. But medicine isn't just about data. It's also about people. That's where the ethical dimension comes in. You're dealing with human beings, not just diseases. So respect, autonomy, and compassion must guide your actions. And finally, there's the legal dimension. Every medical act occurs within a regulated framework. There are laws, guidelines, and professional responsibilities that you must follow, not just to protect yourself, but to safeguard your patients. Here's something essential to understand. A medical act doesn't need to be written down to take effect, but without documentation, it has no legal weight. So while the act itself may begin informally, it becomes complete when it's properly recorded, both for the patient's continuity of care and for your own legal protection. Now that we've defined what a medical act is, we need to answer a basic but critical question. Who is legally allowed to perform a medical act in Mexico? The answer is very clear. Only individuals who hold a medical degree and a valid professional license, or cedula professional, are legally authorized. This is not just a policy. It's the law. According to Article 79 of the Ley General de Salud, or General Health Law, and Article 250 of the Código Penal Federal, or Federal Penal Code, any person who practices medicine without proper credentials is committing a criminal offense. Now, does this mean that other healthcare professionals aren't important? Of course not. Nurses, psychologists, physical therapists, and others are essential in patient care, but they each have defined scopes of practice. The diagnosis, the prescription of treatment, and the issuance of medical certificates. These are exclusive functions of licensed physicians. They cannot be delegated, and they cannot be shared. In other words, the medical act is indivisible, and when someone without proper legal authority performs it, not only is it invalid, it's punishable under criminal law. This clarity in roles is vital for teamwork, for patient safety, and for the legal protection of everyone involved. The medical act is not a one-time decision. It's a structured clinical process that unfolds step by step. It begins with the initial assessment. This is where you gather the patient's history, perform a physical exam, and request diagnostic tests when necessary. It's more than just listening. It's the foundation of everything that follows. Next comes the diagnosis, the interpretation of the data you've collected. This must be a reasoned conclusion, supported by clinical evidence and sound judgment. Then we move to the prognosis. Here, you anticipate how the condition might evolve, with or without treatment. You take into account not only the disease, but also the patient's context, social, emotional, and biological. Based on that, you define the treatment plan, the set of interventions that aim to improve or stabilize the patient's condition. And finally, there's follow-up. Because the act of healing doesn't end with a prescription. You need to monitor, adjust, and be present through the evolution of the case. Each of these phases is part of the medical act, and here's the key point. Every phase generates responsibility, and every decision must be documented. Even though the medical act doesn't legally require a written format to occur, without proper documentation, it cannot be defended, not ethically, not clinically, and certainly not legally. Recording your actions protects the patient's continuity of care and protects you, the physician, in case of any doubt or legal challenge. Let's talk about something that often feels secondary, but it's actually vital. Documentation. Medical notes are not just bureaucratic requirements. They are a fundamental part of the medical act itself. Each time you attend to a patient, your assessment, your reasoning, and your actions must be recorded. Why? Because that note becomes part of the patient's clinical history, and it also becomes your legal testimony. Documentation ensures that other colleagues can understand what's been done, the patient receives continuous care, and your decisions can be evaluated and defended if needed. In Mexico, the key regulation for this is NOM 004 SSA 3-2012, which governs the structure and content of the clinical record. or in Spanish, Norma Oficial Mexicana del Expediente Clínico. Following this standard isn't just about avoiding penalties, it's about delivering safe, traceable, and accountable care. And let me emphasize this point clearly. If it's not written, it didn't happen. It may sound harsh, but that's how the legal system works. A good physician who documents poorly can be left vulnerable, while a physician who documents thoroughly is far more protected. So, yes, documenting takes time, but it closes the clinical loop, ensures continuity of care, and protects everyone involved. Let's now talk about informed consent, one of the most ethically and legally significant aspects of the Medical Act. Informed consent is not just a signature on a form, it's a process of communication, a dialogue between physician and patient. It's the moment where we explain, and the patient understands and decides. What must we communicate? The nature of the procedure, its risks and benefits, possible alternatives, and what could happen without treatment. And we must do this using language that's clear, honest, and adapted to the patient's level of understanding. Now here's something important. Only the treating physician can give this explanation and obtain valid consent. This task cannot be delegated, not to residents, not to nurses, not to administrative staff. According to Mexican law, specifically the Ley General de Salud, its Reglamento en Materia de Atención Médica, and NOM 004 SSA 32012, this process must also be documented properly. And what about emergencies? In life-threatening situations, when the patient cannot give consent, the law allows presumed consent. But once the emergency is over, everything must be documented, including the justification for acting without formal consent. Here's a crucial point to remember. A signature alone does not prove valid consent. If the patient didn't truly understand, the physician is still legally and ethically responsible. Informed consent is not a shield, it's a bridge. It protects the patient's right to decide and strengthens the trust that should always exist between doctor and patient. Every medical act takes place within a legal and ethical relationship, and at the center of that relationship is the patient's rights. In Mexico, patient rights are recognized in documents such as the Ley General de Salud, General Health Law, and the Carta de Derechos Generales de los Pacientes, or General Patient Rights Charter. What do these rights include? The right to receive clear and sufficient information, the right to accept or refuse treatment freely, the right to privacy and confidentiality, and the right to respectful, humane, and dignified care. These rights are not optional. They are not dependent on the hospital's resources, the patient's background, or how busy the service is. They are non-negotiable and legally enforceable. It's also important to understand that many complaints in medicine do not arise from technical mistakes, but from situations where the patient felt ignored, disrespected, or uninformed. That's why respecting these rights is not just an ethical duty, it's part of delivering quality care, it's part of building trust, and it's part of what makes a medical act complete. In the end, the science you apply and the procedures you perform are essential. But what will define the patient's experience is how they were treated, as a person, not just a case. Every medical act, no matter how routine it seems, carries professional responsibility. This responsibility can manifest in several ways, depending on the nature of the action, or omission, and its consequences. Let's break it down into three main categories. First, we have ethical responsibility. This arises when the physician acts against the principles of the profession, like honesty, confidentiality, or respect. It may lead to warnings, suspensions, or sanctions from professional bodies or ethics committees. Next is administrative responsibility. This happens when institutional or regulatory guidelines are violated. For instance, if a physician disregards official clinical protocols or fails to meet documentation standards. The consequences can include fines, suspension, or even disqualification from public service. And finally, we have legal responsibility, which can be civil, if the patient suffers harm and demands compensation, or criminal, when the physician's conduct is considered reckless or negligent enough to be punished by law. In Mexico, these forms of liability are governed by the Ley General de Salud, General Health Law, the Código Civil Federal, Federal Civil Code, and the Código Penal Federal, Federal Penal Code. So what's the takeaway? Being aware of these responsibilities doesn't mean practicing medicine in fear. It means practicing with judgment, ethics, and awareness. When you know the law, follow professional standards, and communicate with your patients, you're not only fulfilling your duty, you're also protecting yourself. When evaluating whether a medical act was performed correctly, the key concept we turn to is the lex artis ad hoc. This Latin phrase refers to the standard of care that's expected of a physician under specific circumstances. It's not a fixed checklist, it's a flexible standard based on medical knowledge, professional ethics, and the unique clinical context of each patient. So what does this mean in practical terms? It means that a physician isn't judged by whether the patient was cured, but by whether their actions were appropriate, reasonable, and consistent with accepted medical practice. This is where we introduce a fundamental legal principle. Physicians in Mexico, and in many countries, have an obligation of means, not of results. That is, an obligation of means, not of outcomes. You are not legally required to guarantee healing. You are required to use the right tools, knowledge, and judgment to apply the best possible care based on what was available, reasonable, and medically sound. If you meet this standard, the lex artis, even if the outcome is unfavorable, your actions are ethically and legally justifiable. But if you fall short of that standard, if you act without the necessary skill, knowledge, or prudence, then you may be considered negligent, regardless of your intentions. So remember, the outcome matters. But how you got there matters more. And the best way to show that you followed the right path? Through clear documentation and adherence to evidence-based protocols. So what happens when the medical act is not performed correctly? When a physician deviates from the lex artis, from what should reasonably be done in a given clinical situation, we may be facing a case of medical malpractice. Let's look at the three most common forms. First, there's negligence. That's when a doctor fails to act. For example, not ordering necessary tests or ignoring obvious warning signs. Second, we have imprudence. This is when action is taken, but in a careless or rushed way, like performing a procedure without proper indication or patient consent. And finally, imperitia, lack of skill or competence. This happens when someone attempts something beyond their level of training, like using equipment they were never certified to handle. But here's the thing, for legal liability to exist, three elements must be proven. 1, that the act or omission occurred. 2, that the patient suffered harm. 3, and that there's a direct causal link between the two. So it's not enough to say something went wrong. There must be proof that what went wrong was due to a failure in medical duty. And as we've said before, if it's not documented, it didn't happen, legally speaking. A physician may provide excellent care, but if there's no record of what was done, the defense weakens, or even disappears. That's why avoiding errors is important. But documenting what was done correctly is just as critical for protection and transparency. Let's move from theory to real-life situations. Understanding how medical liability works is much easier when we look at common everyday examples, scenarios you might encounter in your own practice. Here's the first one. A patient comes in with clear signs of a serious condition. The doctor does not order tests, doesn't follow up, and the patient deteriorates. That's a classic case of negligence. The physician failed to act when action was clearly needed. Next, a procedure is performed without proper informed consent. Maybe the form was signed, but the explanation was rushed or incomplete. That's imprudence, taking a risk without justification or proper communication. Another common issue, lack of documentation. The doctor gives excellent care but never writes a note. Later, when a complaint is filed, there's no proof of what was done, and no way to defend it. Now let's say someone uses a medical device they've never been trained on, and something goes wrong. That's imperitia, a lack of technical competence. And finally, violating confidentiality. Even casually discussing a patient's case in a non-clinical setting or sharing an image without consent can lead to sanctions. These aren't extreme or rare cases. They happen in hospitals, clinics, and consult rooms every day. That's why understanding professional responsibility isn't just for lawyers. It's an everyday part of clinical reasoning, of ethical care, and of protecting yourself and your patients. Let's now look at the legal framework that regulates the medical act in Mexico. As you've seen, being a physician is not just about making clinical decisions, it's also about practicing within a regulated system, where laws and standards define what's expected and what's allowed. At the top of this framework is the Ley General de Salud, the general health law. This law outlines who can practice medicine, what rights patients have, and what responsibilities health professionals carry. Supporting this, we have the Normas Oficiales Mexicanas, or NOMS, official Mexican standards that define technical and administrative procedures in specific areas of healthcare. A crucial one is NOM 004 SSA 32012, which regulates the structure and content of the clinical record, including documentation, notes, and informed consent. There are also NOMS for emergency care, mental health, obstetrics, and many other areas. Together, they set the minimum standards of care that all professionals must follow. Additionally, we have the Reglamento de la Ley General de Salud en Materia de Atención Médica, a regulation that specifies how services must be organized and who is responsible for each action. Finally, the civil and penal codes define the legal consequences of failing to meet those standards, whether it's financial compensation or criminal responsibility. Now here's something essential. Not knowing the law does not exempt you from its consequences. As physicians, we must not only stay current with medical knowledge, we must also understand the rules that govern our profession. Because when something goes wrong, being able to say, "I didn't know," will never be enough. In modern healthcare, we work as a team. Physicians, nurses, psychologists, nutritionists, physical therapists, each professional contributes something essential to the patient's well-being. But in Mexico, when we talk about the Medical Act, there's a legal distinction that must be made. Only a licensed physician, that is, someone with a medical degree and valid cedula professional, can perform certain key actions: clinical diagnosis, prescribing medical treatment, and issuing medical certificates. These activities are reserved exclusively for physicians by Articles 79 to 83 of the Ley General de Salud, the General Health Law, and NOM 019 SSA 32013, which defines the professional scope of nursing practice. Now, does this mean that other professionals are less important? Absolutely not. But it does mean that each member of the healthcare team must work within their legal scope of practice. And that matters. For patient safety, for ethical clarity, and for legal protection. If a nurse adjusts a treatment plan without a physician's order, or if a technician offers clinical advice, they may be stepping into the domain of the Medical Act, and that can lead to serious consequences. Working in teams doesn't mean everyone can do everything. It means each person knows their role, respects the boundaries of others, and collaborates responsibly. When those roles are clear, patients benefit, and the whole system works better. Practicing medicine today is very different from what it was a few decades ago. The Medical Act is still central to healthcare, but it now faces new and growing challenges. One of the most significant is legal pressure. We're seeing an increase in complaints, legal claims, and public scrutiny. Even when the physician follows proper standards, complications or poor outcomes can lead to legal action. This creates fear. And with that fear comes something called defensive medicine. That's when doctors begin to order extra tests, hospitalize unnecessarily, or avoid complex cases, not because it's clinically justified, but to protect themselves from potential complaints. Defensive medicine may feel safe, but in reality, it drives up costs, overwhelms the system, and may even expose patients to unnecessary procedures. Another challenge is bureaucracy. We're spending more and more time filling out forms, writing reports, dealing with audits. While some of this is necessary, it can take time and focus away from patient care. And then there's over-reliance on technology. Yes, tools like imaging and lab tests are powerful, but they cannot replace clinical reasoning or human connection. We risk becoming technicians instead of thinking professionals. We risk forgetting that the most important instrument in medicine is the physician. So, what do we do with these challenges? We adapt, but we don't lose our essence. We keep using science and tools, but with judgment. We document responsibly, but without letting paperwork replace presence. And most of all, we continue to see the patient not just as a case, but as a person. We've reached the end of this session, but in reality, we've just laid the foundation for everything that follows in this course. What I want you to take away is this. The Medical Act is not just a technical procedure, it's a legal and ethical commitment, one that defines your relationship with every patient you will care for. Each time you interview, examine, diagnose, treat, or decide not to act, you are exercising a medical act, and that act creates responsibilities for you, generates rights for the patient, and must align with professional standards, ethical principles, and the legal framework that governs medical practice. You are not expected to guarantee results, but you are expected to act with competence, diligence, and integrity, following the lex artis ad hoc and documenting your decisions clearly. In this course, we'll later explore topics like informed consent, clinical records, medical liability, and ethical dilemmas. But they all start here, with this core understanding. So as you continue your medical training, I invite you to see each clinical encounter as something more than routine. Because behind every note, every prescription, every decision, there's a person, and a profession, and a law that protects them both.